Welcome to Legal Straight Talk. I'm Brett Harrison. I'm really excited for tonight for our guest, Mr. Anthony Ballato. He's an attorney that he handles cases that you hear a common phrase all the time: lemon law, lemon law. This car is a lemon. This is a lemon. So today we're fortunate enough to have an expert, I like to call, in lemon law. Thank you for coming tonight, Anthony. Welcome to the show.
Good evening, and thank you for having me.
Okay. Well, let's get to the heart of the matter. People often they buy cars, whether it be used or new, and they say, if this is a lemon, I'm returning it. I'm going to get my attorney. But let's really dissect that. Let's really pick that apart for them. First off, what does the lemon law cover?
Okay. Well, if I can back up a moment, and I think you and the viewers will appreciate this, we're going back to the early 1960s when we were children, and it started with Ralph Nader, somebody that everybody's familiar with, started the consumer movement of going against the manufacturers. And at that time, Ralph published a book, Unsafe at Any Speed, something personal injury attorneys would appreciate, as well as consumer advocates like myself, because he went against the manufacturers, saying not only are you putting unsafe products into the marketplace, but also you're not standing up to your warranties. So that started in the 1960s. Unfortunately, it took most states and the federal government about 20-something years to enact what are now nicknamed the lemon laws, or various state and federal statutes enforcing or giving certain enforcement rights to consumers, purchasers of automobiles, vehicles, even motorized wheelchairs and motorhomes, the ability to enforce their rights.
If I'm not mistaken.
And motorcycles were added some years later. The only thing that's excluded are classic cars, as defined under the New York law, and off-road vehicles.
Now, are these lemon laws in most of the states now?
I believe every state has some form of a lemon law statute, and they vary. Certain states, like in Wisconsin and California and Texas, they have very strong statutes that enable consumers to get up to triple damages and punitive damages in these cases. Unfortunately, New York falls into some of the weaker statutes.
Now, when you say consumer, you're just talking the average person that just goes in. He's a non-dealer. Is that fair to say? Or?
Well, we have to distinguish right at the very beginning two things. Are we talking about the lemon law or other statutes?
Well, let's just talk about the lemon law, because as maybe we can get to later, sometimes the lemon law doesn't necessarily apply, and there's other laws in New York and other causes of action that may well apply.
That is correct. So what I like to do, being a consumer advocate, is my analysis always begins with, is the lemon law applicable to this particular consumer's complaints or set of facts? So to be a consumer, you have to be a purchaser of a vehicle, and the vehicle for New York purposes is basically an automobile, a motorcycle, a motorhome, or even a motorized wheelchair. And one of many other key elements is that you're purchasing it from a dealer, not a private individual, or that it's coming from a manufacturer, because the law applies to both new and used vehicles up to a certain age, going back to 1983.
Is there a dollar limit on used vehicles? That it has to be over $1,000, $2,000, $10,000?
That's correct. The used car lemon law mandates that, at least in this state, the vehicle has to be purchased at a price of at least $1,500 or more.
So it's almost, to me, like it's almost like David versus Goliath. It's a way for when you bring in Ralph Nader, that just usually puts in my mind the small guy versus the unlimited pockets, which, when you said, it's a way of going against manufacturers, dealers, and so forth. It makes it more manageable, almost as a cause of action to me.
That's correct, and some other consumer advocates who have written books on this topic use just that analogy of the David versus Goliath, and that but for having these statutes to empower the little guy, they wouldn't have the slingshot necessary to take out Goliath.
And that's important, because a lot of times people feel overwhelmed. They say, yeah, I'm going to go up against X dealership or X manufacturer. And they say, you know what, it's not worth it. It's going to cost me more than it's worth. Now, when people come to you, the consumer, if it's not necessarily a dealer, as far as a new or used dealer, but it's somebody that, let's say, what's defined as a dealer? Because some people sell cars, 10, 20 cars. You know, they buy certain cars, they fix them up, and then they sell them. I mean, how is that defined?
All right, well, the first distinction of many that we have to draw when analyzing a client's claim is, are we talking about a new vehicle or a used vehicle?
Used, let's say used.
But first, let's say any used vehicle, new vehicle, up to the first 18,000 miles, okay, will fall under the new car lemon law, even if it was purchased as a demo. And those claims are against the manufacturer, not against the dealer. We focus on the dealers more so when dealing with used cars, and those are ones that have up to 100,000 miles on them, but over 18,000 miles.
Is there a time limit, how long you can have is it 18,000 or is it up to 2 years when you buy a used car or anything like that?
There are different time limits. Let's talk about first the outer time limit, which attorneys refer to as the statute of limitations. On all these cases, it's 4 years from the date of delivery to that consumer. Past that, your statute of limitations is exhausted.
Well, let's put it in plain English for.
Yes.
That means if you don't do it within a 4-year period,
if you don't commence the action or proceeding within 4 years,
then you're out of the box
for lemon law purposes.
For the purpose of the lemon law.
Correct.
And commencing or starting an action, you would say would either be purchasing an index number, or is it just a letter, certified letter? I mean, is there a way of putting them on notice?
Yeah, consumers or their advocates have two choices. You can either proceed in this state in the Supreme Court in what's known as an action, or you can proceed under the New York Attorney General's arbitration program, which is very favorable for many people because it's a much faster, easier, kind of almost like a small claims kind of proceeding that takes just a few months and is a inexpensive procedure. And
as you can attest to as an attorney, once you put something in the courts, it's not a few months.
Yeah, well, to let people know is my average or the average arbitration under the New York Attorney General's lemon law proceeding is a few months. For a new vehicle, it's a $250 filing fee. For a used vehicle, it's a $120 filing fee, versus bringing an action in Supreme Court, as you know, is about a $170 index number fee plus service of process and other things. So a minimum of about $500 up front, and usually takes 2 to 4 years to go to trial.
And then there's a whole bunch of discovery and conferences, and that's when you hear people complain, consumers complain, my lawyer's charging me for all these appearances and nothing's getting done, the other side's not turning over information, whereas the arbitration, it takes away, it slices the whole procedure.
Not only that, but the key is that most folks can only afford one vehicle, and it is required in any of these proceedings that the consumer maintain that vehicle throughout the pendency of the matter. So if you have a lemon and it's not reliable, and it's putting your job at risk, or it's putting your family in danger, you can't keep that car for 2 to 4 years, pending a Supreme Court action, unless you got to go buy another one. Otherwise, the other side can complain that you've spoiled the evidence, or you've mooted your case by disposing of the vehicle.
Now, if you put it into arbitration, does the defendant, the manufacturer, the dealer, or what have you, do they have a right to get that car inspected?
Yes, they can request that the vehicle be produced for inspection, and that is a very important aspect of representing people in these cases, because there's a difference between what I say inspecting or tampering, because there are many instances where the dealer or manufacturer may try to alter something in the vehicle before the hearing or before the trial to make that problem disappear.
That in itself, and if they get caught doing that, then what happens?
Oh, that's substantial. But just like in any other case, whether it's medical malpractice and doctors who are accused of doctoring the records, right? We all know that happens. All right, unfortunately,
it's tampering, it's spoiling. There's so much to that. Now, how much time do they have? Let's say I file it January 1st for the arbitration. Okay, and I'm sure you pay the $250. I'm sure you have to show proof of service of some sort. How long does the other side, the dealer or the defendant in this case, have to inspect the car?
You know, the statutes do not provide a limitation on that. The practical reality is it need be done before the hearing, or as late as at the hearing, you can perform a visual inspection. The other thing I should add, a lot of people aren't aware of this. We've all heard with airplanes of black boxes, which they're actually orange, okay, but they're referred to as black boxes because of the unfortunate data that they contain. Most modern automobiles have similar little black boxes, if you will, that record all sorts of data on the vehicle, anything from top speed, top RPMs, braking, accelerating, all sorts of conditions that can be downloaded to computers, analyzed by manufacturers or dealers, and sometimes used against the consumer to claim that they have abused or neglected or exceeded the proper use of the vehicle.
And there's where the tampering comes in, and that's why they want to inspect the cars, should that have happened on the reverse of it.
Right, and fairly so, unless, again, when they're displaying all their charts and graphs on their computers, does the arbitrator or even the other attorney really know that that's the data from this vehicle, or is it perhaps the data from another vehicle?
And that comes into a whole thing of proof issues and certification, I'm sure. But I think usually in arbitration, the rules of evidence are kind of lightened.
They're much relaxed. The rules of evidence in arbitration, or at least in lemon law proceeding, are pretty much out the window, and almost anything goes.
So you could just hand in things without an expert, or do you need you need an affirmation or an affidavit of any sort?
Well, of course, it's always best to have an expert, and very often the manufacturer or dealer has an army of experts. They have the certified mechanics. They have their own FSCs, field service engineers, and other people at their ready disposal, whereas consumers have to now hire and bring in an expert. Not always, but sometimes.
Well, how much are some of these? Let's say you had to hire, the consumer wants to hire, an expert. Is it 1,000? Is it 2? Or,
It varies on the type of expert and the type of analysis. So if you're engaging someone who is typically a retired but still certified mechanic, they might charge a few $100s for an inspection and report, and a few $100s for like a half a day's testimony. If you're hiring an automotive engineer or an accident reconstruction specialist, you're talking about thousands of dollars up front and during the hearing.
Now, let's say the consumer is successful. Okay, successful meaning they find that there was a violation of lemon law. Are they entitled, like in some other civil cases, to their expenses? Let's say it cost them. They needed an engineer, and it cost them, $2,000 for the testimony, as well as another $500 for a report. Are they entitled to that money back on top of whatever award, or how do the awards work?
Well, here now we have to draw another distinction between the New York lemon law and some other statutes, such as on the federal end, what's known as the Magnuson-Moss Warranty Act, which that act provides.
I can't even spell that.
Yeah, well.
what, is there a shorter term for that, or that's just...
Yeah, the short term is they call it MAGMOS. You always hear people referring to MAGMOS, which is a federal statute. And what MAGMOS provides is that a successful consumer, so you don't have to worry about the manufacturer or dealer being successful in getting its attorney's fees, shall get its reasonable attorney's fees. And interestingly enough, there have been some cases. There was one case out in the state of Wisconsin that was against Mercedes that resulted in an award in excess of $400,000. There was another case out of the state of Alabama known as BMW versus Gore, I believe, which interestingly enough, that state, under its statutes, awarded punitive damages first of $4 million.
Well, explain to our consumers what punitive and give an example of that so they would understand.
Punitive damages are also known in the law as exemplary damages, and that's to teach.
So that's almost like,
yeah,
we're teaching Goliath a lesson?
But that's to teach a bad guy, a bad manufacturer, who has done this kind of thing many times over, that basically is harming the public, not the individual plaintiff or consumer, to stop them and deter them from future bad behavior. But let me go back a moment again to those statutes and awards. So even the New York lemon law provides, and this is a very interesting distinction, where the statute is somewhat ambiguous, that a successful consumer can be awarded its attorney's fees by a court. So unfortunately, our Attorney General in New York, because of the word court, has not allowed its arbitrators in its own arbitration proceedings to award attorney's fees, but say that you then have to go to Supreme Court to confirm the award or begin in Supreme Court in the first place.
So they take it and then give it away.
That's right.
So the advantage on the one hand is speed.
Yes.
You'll get a date very quickly, but now even when you get a date, that also can, how often will they allow that to be adjourned, or what I like to call jerked around by the other side?
Again, if you're diligent and you're on top of your case in arbitration, you're looking at 2 to 4 months, perhaps.
Oh, they don't let a lot of adjournments for the other side?
No, each side is entitled to one request for any reason, and then maybe another request for cause. No, there's not a lot of adjournments in arbitration, but as you know, in Supreme Court, there's adjournments for months and years, for all sorts of reasons.
And often you get people in Supreme Court that just show up for the day, or called per diem, that say, I don't even have the file, I'm just here to adjourn the case.
Correct, unfortunately.
But now that doesn't happen with the arbitration, because they could actually make you say, no, that's it.
That's correct.
And how long are the typical hearings? Do they give you an hour, 2 hours, or is it case by case?
They're pretty liberal, the arbitrators. I've been at hearings that were maybe as short as 2 hours and as long as 2 full days.
Now, let's stay with the arbitration. We like to call in the industry, what's your burden? Because you're the plaintiff, you're bringing the case forward.
Yes.
You now have the burden of proof to show a violation of under the Lemon Law. What do we have to prove?
Okay.
As the plaintiff?
In an arbitration proceeding, it's not that tough of a burden, and there's a statutory presumption, and it goes like this: a consumer has to show that there is a defect with the vehicle that does one of two things. It either substantially impairs its value to the consumer or concerns a safety defect. So it has to be one of those kind of problems, not just any kind of problem, and that the dealer or the manufacturer, in the case of a used or a new car, was afforded, as defined in the statute, a reasonable opportunity to repair the vehicle. The statute goes on further to say, in a used car case that's 3 or more times or 15 or more days out of service, or in a new car case, 4 or more times or 30 or more days out of service. Once those things are established, now the burden of proof shifts to the manufacturer to show why that vehicle is not defective, and then the consumer should not prevail.
And that they use all reasonable abilities to
they don't have to
even address it,
no,
or it's just that it's just still not...
It's as simple as that, and quite frankly, what a lot of folks don't know is, after many years, the Attorney General's office has developed a certain form checklist. So the arbitrators are given a checklist, and it's kind of fill in the box, and a lot of people can't put a round peg in a square hole.
Right.
So they look at those things, and the magic numbers are, as I said, either 3 or more times out of service for a used car, or 4 or more times. Or what I like to say to my clients, if think of baseball, 3 strikes you're out in the used car case, 4 strikes you're out in the new car case, or the 15 or 30 days.
Now, on a used car case, where does repair fit into this?
Okay.
I know that might be a very broad question, but...
No, and that's very important, because with a new car, a consumer can take a vehicle anywhere to an authorized dealer. So, and I'm not picking on a particular make, but let's say Chevrolet. I buy a new Corvette in New York, and I decide I'm moving to California. I can fix it there, or along the way, I may decide in Illinois I need some repairs.
But it has to be a certified...
It has to be a authorized dealership of General Motors or Chevrolet.
It just can't be some general gas station.
No, it has to be
gas station.
It has to be an authorized dealership. That's for new vehicles. But for used vehicles, what a lot of consumers don't know, you have to go back to the selling dealership. So the problem arises where clients buy cars out of state. So a guy in Pennsylvania decides to buy a car in New York and then has it repaired in Pennsylvania and doesn't tell the dealer in New York. That's not a strike against them, because they weren't given a reasonable opportunity to repair the vehicle.
Now, do you recommend, when you have problems, let's say it's a used vehicle or even a new, would you put it in writing to them and send it to them, or would you just make sure you note the date and the time, or you you'd have a slip stamped? I mean, how do you do that to prove?
Documentation is crucial, whether it be repair orders, emails, or some other communication, or, when someone like me gets retained, a certified letter documenting right then and there what happened before those time limits elapse.
So now also, when you're the cost for the arbitration, you said, was how much?
The New York fees are $120 for a used car, $250 for a new car, and that gets payable to a organization called NYDSTRA that arbitrates the proceeding. That's the filing fee, if you will.
As a used dealer or a new car dealer, you agree, if you're in New York State, to that arbitration? It's mandatory if...
No, it's not mandatory. It's optional. The consumer has all sorts of choices. The first choice is...
No, I'm saying, can they opt out of that?
The consumer?
No.
The manufacturer?
The manufacturer
No,
or dealer?
it's mandatory to the manufacturer or dealer. It's the consumer's
That has
choice,
the choice, of
as
course.
to what we'll say forum that they want to sue in, whether it be Supreme Court or the arbitration proceeding. And there's another one we haven't talked about. The Better Business Bureau has an arbitration program, which is a lot different than the Attorney General's program.
And what's that program?
Okay, the Better Business Bureau, and everybody I think is familiar with BBB, okay, which has been a long time. That is a voluntary program, and some of the key distinctions between that and the Attorney General's mandatory program is that the consumer has the option of filing there.
Is it sort of like you see it with, and I want to get into this part of it, after 9/11, the construction people, there was a lot of construction for it. So the Better Business Bureau a lot of times got involved, and that even got the Better Business Bureau, got the DAs involved.
Well, not so much with these automobile cases. The Better Business program is more like a mediation, and I'll say why. Its decision is not binding on either party. So if the consumer elects to proceed in BBB, and either party doesn't like the decision, they can still proceed elsewhere. So it's not binding, problem number one. And number two, I have an issue with the BBB, is that they have three results. You can have a decision for the manufacturer, a decision for the consumer, or what's called a decision for further repairs, where the arbitrator tells the manufacturer or dealer, we want you to make further repairs on this vehicle.
But if it's not binding and one side doesn't like it, no, I'm not.
So that's why a lot of folks don't bother with that program.
Especially since the arbitration, is that appealable? The decision?
The decision from the Attorney General's program, and it's appealable in what's called an Article 75 proceeding. It's a proceeding to vacate or modify an arbitrator's decision, and that has to be brought in the Supreme Court.
And I would imagine that's typically done more on probably more expensive decisions, more expensive.
Absolutely, and also on cases where they're very strong. So courts often defer to the better judgment of the arbitrators in a lot of these types of appeals, if you will, for arbitrators' decisions. So in cases where, let's say, there was a clear violation of a statute. So, for example, one of the things under the Lemon Law is that the vehicle has to be primarily used for personal, not business use. And the Attorney General's office has determined that to be somewhat more than 50%. And what some dealers or manufacturers like to do is pick on folks who they or their accountants have depreciated the vehicle on tax returns for legitimate tax purposes for more than 50%, and then they jump in, if they can get copies of the tax returns, and say, aha, the Lemon Law doesn't apply to you, and they look to have a case dismissed. But where when you go through the testimony, maybe a person is running an appraisal business, and they're driving to the grocery store, and they're picking up the kids at soccer games, and they're going back and forth from their office, and that's arguable as to whether it's a business or personal
They're
use.
allowed to get the tax returns?
Yes and no. It depends on your arbitrator. There's a system under the program called a request for documents that requires it be submitted to the arbitrator for approval. And what some of the adversaries, if you will, on the seller's end, demand tax returns. Now, smart counsel or consumer will say, wait a minute, you're being too invasive. I'm not giving you all my tax returns.
Expedition.
And it's harassment in some cases, really. And what a wise arbitrator will do is either deny the request because it's overburdensome, or they will limit it to just that portion of the tax return that discusses vehicle depreciation. And if a person says, but I didn't depreciate my vehicle on my tax return, then they